A very warm welcome to everyone to our webinar today, which is part of the World Commission on Environmental Law's webinar series, The Transformative Power of Law, Addressing Global Environmental Challenges. This webinar series aims to look at contemporary developments in international and national environmental law, and is meant to provide a platform for discussion and mutual learning. My name is Christina Voigt. I am the chair of the IUCN World Commission on Environmental Law, and for that reason, I have the privilege of welcoming both our participants and speakers and moderators today. Today, we will discuss the topic rights of nature towards transforming our relationship with the environment. And as you perhaps know by now, but definitely by the end of this webinar today, the topic of rights of nature is something that is currently widely debated and practiced, and is something that is under very fast development in many jurisdictions worldwide, and also on the international level. There's a lively debate about how this can also be reflected in international law. This issue of rights of nature is at the core of a new task force at the IUCN, the International Union for the Conservation of Nature, which is a collaborative approach from the side of the Secretariat, the IUCN Secretariat, and the World Commission on Environmental Law, and it's jointly administered by the World Commission on Environmental Law. And here our lead on the task force, Professor Philip Cullett, he is with us today from the SOAS University in London, and his counterpart is Sabrina Nick from the IUCN Secretariat, and they are the Director General's office, and Sabrina is also with us, and they both will be moderating the webinar in just a minute or a second. Today we will be discussing recent developments in the field of recognition of rights of nature, which implies the granting of individual legal personality to nature, to natural aspects like rivers or national parks or lakes, as a legal object, as a legal subject with legal personality. That means we see a shift from looking at nature as a legal object towards a legal subject with rights in its own right, so to say. Before I give the floor to both Sabrina and Philip, please let me give or say a couple of thanks to both the presenters that are with us here, and to both Sabrina and Philip for organizing this webinar, and also to the Executive Officer of the World Commission on Environmental Law, Roberto Cole, who is here in the background, who helped us organizing this webinar and also recording it. And the recording will be made available on the IUCN World Commission on Environmental Law's website for anyone to listen at a later point in time. And without further ado, it is my great honor and privilege to give the floor to both Sabrina and Philip for the moderation of this webinar. Thank you so much.
Thank you, Christina, for opening the webinar and for the opening remarks. It's a pleasure to be here with you today. I also welcome you from the IUCN Secretariat side to this webinar. As Christina mentioned, I'm leading on the Rights of Nature project from the Secretariat side, and Philip and I will start by giving you some overview what we are doing in this project of rights of nature. We will then go on and present the panelists that are here with us. We're really honored to have some excellent guests with us. We will then go in an active exchange of questions throughout the whole webinar, and at the end of the webinar, we will address questions that you might have listening to the interventions. So whenever there is something that pops up that you would like to know, don't hesitate, put the question in the chat, and we hope to make sure that it will be addressed at in a smart period at the end of the webinar. I think that's from our side for the starting words. And then let's move over to introduction of the task force on rights of nature. As Christina already mentioned, it's a joint project from the Commission, the World Commission on Environmental Law and the IUCN Secretariat. And this was actually initiated by a mandate from IUCN members. Some years back, the members said to the Director General, start working on the rights of nature, initiate the process that starts discussions, maybe even with the end aim of having rights of nature accepted at the global level, but the process needs to start. So that's where this task force comes in. IUCN aims to provide with its waste memberships that includes NGOs, state agencies, government members. We also have indigenous peoples that are member, and most recently, we also count subnational governments to our members. So we have this huge membership. We also have experts on environmental law that are part of the commission, as many of you are here listening to us. So this brings together a wealth of network where we can provide a space for discussion, sharing best practices, and advancing the topic together. And I will let Philip elaborate a little bit more in details on the objectives of this project. Thank you.
Okay, thank you. Welcome also from my side. So carrying on in terms of the introduction of the task force, the objectives that have been given to it based on an earlier 2012 resolution of the IUCN. So it's kind of a long-term process that is slowly maturing. The task force on the right of nature has been given the following objectives. First is to analyze the consequences of granting legal personality to ecosystems, species, natural spaces, and so on, and discuss the kind of right that this may entail. Second is to consider the ways of rethinking the relationship of humans with the environment towards understanding nature and having entitlement of its own. And third is examine ways in which the right of nature can help us rethink the place and the role of nature, society, and the economy. Now, in the longer term, the longer vision is the idea of promoting the development of a universal declaration of the rights of nature. Again, that goes back to the 2012 resolution. And more broadly, maybe on the way to that declaration would be to build some more of a common language to talk about the rights and discuss them in a way which is understood in relatively similar around the world. And that's why today our panel for this matter is wonderful. Okay, we have forced our panelists to be either up very early or very late, but that also ensures that we really have representation from around the world in the limited frameworks that we have today to discuss these different framings and the different ways in which they arise. Okay, and this being said, we'll move to the introduction to the panelists, where we have also divided ourselves since we are two moderators. So I'll start in the order in which the panelists are going to speak in their main presentation. So the first is Dr. Jaffa Epstein of Uppsala University. Her research has focused on interdisciplinary methods in law and ecology, particularly applied to EU environmental law and to rights of nature. And within this context, her research and her publications reflect directly her very integrated engagement with rights of nature. Her latest article, which I think will be linked to what she says today, is Animals and Nature as Rights Holders in the European Union in the Modern Law Review. An earlier publication is A Positivist Approach to Rights of Nature in the European Union in the Journal of Human Rights and the Environment. She's also the co-convener of the research group on rights of nature and animals under the auspices of the International Association of Constitutional Law, and co-directing a research environment in legal ecology between Uppsala University and the Swedish University of Agricultural Sciences. Starting now.
Thank you. Then I'll go over. The next speaker will be Professor Dr. Hugo Echeverria, and he is an attorney at law and has a Doctor of Jurisprudence amongst many other titles and experiences. He's also a lecturer on environmental law in Ecuador. And one of the things that struck me the most when I was reading his biography is that he has been living for 5 years on Galapagos Islands, working on developing environmental law on the islands. So I'm really excited to hear more about the context Dr. Echeverria will provide us on implementation and jurisprudence of rights of nature in the Ecuadorian context.
Okay, and our last speaker will be Professor Tianbao Qin, who is a Luojia Professor of Law and serves as the Director of the Research Institute of Environmental Law in Wuhan University. He's also the Editor-in-Chief of the Chinese Journal of Environmental Law and a member of the Compliance Committee of the Nagoya Protocol on Access and Benefit Sharing. He's also been an advisor, he is an advisor for the Chinese government on negotiations on biodiversity, seas and climate change. His research concentrates in various fields related to rights of nature, in concerning law and policy related to biodiversity and biotechnology, water in oceans, climate change, energy, environment and health, and transboundary environmental issues. He has widely published in the field of environmental law. Among his various publications is the Research Handbook on Chinese Environmental Law, published by Routledge in 2015.
And with that, thanks again to the panelists for being here. And let's jump into the discussions on rights of nature. So we would like to start with one question that will be addressed to all three of our panelists. And the idea is to have a 2 minutes response, so rather short, so you get a little bit a feeling of the focus areas of each of the panelists. So let's start with the question, which Ms. Epstein will start, and then we go on with Dr. Echeverria and Professor Tianbao. So in your opinion, what is the most important recent development when it comes to rights of nature?
Thanks. So in Europe anyway, the Mar Menor law, last year's Spanish law recognizing the rights and legal personality of the Mar Menor lagoon and its basin, was the first national rights of nature law in Europe. This law is being challenged as unconstitutional, so we'll see what happens. If it's upheld and is effective, it surely will inspire similar laws. And if it doesn't, it might give people pause as to whether rights of nature are workable in Europe. A more recent development that I was tipped off to by a colleague is that in England, the Lewis District Council has hired a mainstream law firm to draft its charter for the rights of the river Ouse to ensure that it will challenge, but not too much, or test, or not too much, what localities in England can do to recognize rights of nature. So in some ways, this is a small thing, but I think it's also important because it shows at least an attempt to bring rights of nature into existing national frameworks in Europe.
Thank you, Dr. Epstein. May I address the same question to Dr. Echeverria on the most important recent development that has taken place for rights of nature?
Putting this conversation into context, I will say that the rights of nature have have helped reactivating the debate on the role of law, the role of what law can do in order to revisit the relationship between humans and nature. The rights of nature have provided an alternative approach to that end. It's not environmental law we are talking about, it's something different. And this is something that we have to, and we will go into more detail later on. And finally, it is interesting to see that Latin America in general and Ecuador in particular are providing practical experiences to be assessed worldwide.
Thank you, Dr. Echeverria. And now the same question to Professor Timbao, the most important recent developments in rights of nature that you have observed.
Yeah, thank you for the question. For me, I think the most important to say is the COVID-19. Everybody have a different understanding and a different feeling about this pandemic, but I think almost all can understand or can see what happened during the pandemic, and especially when the people were locked down in the city. There are a lot of wild animals. They run on the street, and so that event forced us to rethink the relationship between the human being and the nature, and especially if the nature has its own rights. Actually, the WCEL of the IUCN has organized several webinars to talk about the relationship between the human beings, the environment, and the health. From the legal perspective, for example, what's the role of the CITES Convention in control the pandemic? Actually, when we control the pandemic, essentially we are protect the environment, and we are eventually we are protect the right of the nature. So for me, I think the most important thing is the COVID-19 provide a very important point for us to rethink the relationship between the human being and the nature. Thanks.
Thank you very much for all these responses. I think that shows already the wide spectrum that we will address in today's webinar. And with that, I'll pass over the microphone to Philip to go into the main discussion.
Okay, so now what we'll do is we'll give each of the three speakers a chance to say a little bit more from their own perspective on the general topic. Each of them has 10 minutes to address one general question that we have discussed before, and I'll start with Dr. Epstein. The question for you is, we understand you've recently published, as I mentioned before, a paper on the role of science in interpreting rights of nature laws. Could you help us by sharing some of the main findings of that paper?
Thanks for the question. So yeah, I recently published a paper in Science together with Hugo and two biologists, colleagues. But I want to start with the disclaimer that if my comments go, to the extent to which my comments go beyond what's in the paper, they're my opinion. So if you're annoyed with anything I say, blame me. But anyway, in this article, we examined the scientific concepts that are used in rights of nature laws and how courts have engaged with science when applying rights of nature. And our findings show quite simply that we need more and better interdisciplinary engagement on rights of nature. We need this at the legal drafting stages, at the implementation stages, and of course, at the enforcement stages for these laws to work effectively. Now, of course, the need for law to be able to use and interact with scientific information and the frequent difficulties in doing so are familiar in many areas of law, and especially environmental law. But I think that rights of nature laws present new and additional challenges. First, they're using science in new contexts. It may not be possible to understand who the rights holder is at all without reference to natural scientists or natural science, or what rights they have without these scientific contributions. Second, because these types of laws seem unfamiliar to judges and other decision makers, they may be hesitant as to how and when to use science to apply them, even when laws are using similar terms, like the right to be conserved or maintained or restored, or even when they protect similar entities to other environmental laws. So two of the several cases that we look at in this article are the 2020 Lake Erie Bill of Rights case, in which a US District Court invalidated the famed Lake Erie Bill of Rights, which was passed by popular vote in the American city of Toledo, Ohio, and the 2021 Los Cedros case, in which Ecuador's constitutional court invalidated a mining permit that it considered would violate the constitutional rights of the Los Cedros forest ecosystem, as well as the rights of animal and plant species. So, of course, the differences between these cases were larger than just the use of science. In the first case, the court was considering rights enacted at the city level. And in the second, the court was considering a national constitutional provision. But the difference in how the courts considered science is also quite striking. The Lake Erie Bill of Rights established the rights of Lake Erie and the Lake Erie watershed to exist, flourish, and naturally evolve. This law was challenged in court by a farm company in the state of Ohio. The court refused to even contemplate what the new rights meant at all in its decision to invalidate the law. Now, this law was one of many local laws in the US that purported to invalidate permits granted by the state or other authorities that would violate nature's rights, and to invalidate the legal person of corporations who would threaten the rights of nature. These provisions are pretty clearly in conflict with US jurisprudence on federalism and corporate due process rights, and it wasn't surprising that the court struck down the law. However, the court decided the case not on these grounds, but instead ruled that the rights to exist, flourish, and naturally evolve were unconstitutionally vague. In its order invalidating the law, the court asked what conduct infringes the right of Lake Erie and its watershed to exist, flourish, and naturally evolve. How would a prosecutor, judge, or jury decide? This I found somewhat surprising, and the courts do commonly adjudicate matters that have scientific aspects. The court didn't discuss at all any scientific or other sources available that could have been used to help interpret these terms. This decision potentially calls into question the legal system's ability to adjudicate scientific matters, or at least the court's willingness to do so in novel situations. On the other hand, this decision points to a way forward for rights of nature advocates, writing clearer or more scientifically descriptive laws. In the Los Cedros case, in contrast, the Constitutional Court made clear the importance of scientific evidence to adjudicating rights of nature, as it considered whether mining exploration violated its constitutional rights. The court not only heard testimony from dozens of scientists and scholars, It also requested that national or international academic institutions that had performed scientific research in the forest area would submit any information they had that could be useful in the case. In one example of the court's incorporation of scientific concepts into legal analysis, the court considered that nature's constitutional right to the regeneration of its vital cycles, structure, functions, and evolutionary processes required understanding the ecological tolerance principle, which holds that natural systems can only function adaptively within an environment whose basic characteristics have not been altered beyond what's optimal for that system. But there are limits beyond which organisms can no longer grow, reproduce, or ultimately survive. Thus, the court said when the ecological tolerance level is exceeded, it's impossible to exercise the right to reproduce life cycles. So the court extensively referred to scientific sources for this and throughout its decision to help it understand scientific concepts necessary to interpret nature's constitutional rights. Importantly, the court also held that the precautionary principle must be applied when there's a potential risk of serious and irreversible damage to the rights of nature. So this means, according to the court, that potentially damaging activities cannot be carried out unless there's scientific certainty that the rights of nature will not be irreparably harmed. So we can see that scientific input is always going to be needed in rights of nature cases in determining whether human activities violate the rights of nature. These cases demonstrate the importance of scientists to the implementation of rights of nature laws. In the Los Cedros case, the testimony of ecologists, biologists, and other scientists were essential to the court's understanding of who the rights holders were and what activities violated the rights, their ecological function. In contrast, the Lake Erie Bill of Rights was held to be unconstitutionally vague because it'd be impossible to legally determine when Lake Erie's rights were violated. Now, Spain's Mar Menor law, though much more detailed as to the rights holder and rights than the Lake Erie law, has been challenged on some of these same grounds. Because legal decision makers often don't have the expertise to understand the rights and potential duties of nature, interdisciplinary research is urgently needed if rights of nature laws are going to have legal meaning. Well, scientific uncertainty can often not be eliminated. Reducing scientific uncertainty reduces legal uncertainty, and thus helps meet the objection by some judges and others that rights of nature laws are too vague to be applied. Critically, even before a natural entity's rights are violated, scientists and legal scholars can help lay the scientific groundwork for these legal protections to function as intended. The availability of credible scholarly analysis, we argued, would make these rights more tangible and therefore accessible to the judges whose role it is to apply them. Thank you.
Thank you very much, and thank you for not just sticking to time, but being before time. Then we'll move to Dr. Echeverria. The question is, there has been 15 years of Ecuadorian jurisprudence that has shown that a non-anthropocentric approach can exist in the law. There are standards that have been observed to be higher when addressing a problem from nature's interest, and that's something which is very interesting in terms of understanding how rights of nature contribute to the jurisprudence of environmental protection. So if you can tell us a little bit more about that.
Thank you very much. Please confirm if you can see the presentation on the screen.
Very much, yes.
Well, the case of Ecuador to date is the first and only one case following a model of recognizing constitutional rights to nature as a new legal subject of rights. Other countries in Latin America, as we will see later on, excuse me, have followed models of legislation, jurisprudence development, but Ecuador remains as the only country having actually recognized rights to nature in the Constitution. I want to provide a little bit of context on the case study of Ecuador. Ecuador is one of the few mega diverse countries in the world. So this is important because nature is important in the geographical context. Secondly, Ecuador follows a civil law tradition inherited from Spain. So we are a country with a civil code, a penal code, an environmental code following the civil law tradition. And please take note of this element because later on it will be important to make a contrast on how the rights of nature have developed in the legal context. Excuse me. And last, environmental rights are human environmental rights are recognized by the Constitution since 1983. Yeah, 40 years now. And in 2008, that's only 15 years ago, the rights of nature were also recognized by the Constitution. So we have two sets of rights, human environmental rights and the rights of nature. Both complement each other. And well, if we have time in the Q&A section, I will like to discuss why the Constitution made this change. Many reasons, many important and substantial reasons, but one of them was the issue of effectiveness of environmental laws. Yeah. In terms of application, 15 years from now, it is very important for you to know that jurisprudence, not legislation, but jurisprudence is shaping is providing the essential content of the new rights of nature. This is very important because it means that that judges, not legislators, it means that experts on constitutional law, experts on constitutional procedural law, and experts on human rights are telling us what the rights of nature are. Not legislation, not legislators, meaning not politicians. And that is very good in terms of providing a solid content for these new rights that that with no doubt set for many legal controversies. Okay? So judges and not legislators, I insist on this idea, are shaping the content of these new rights. And the last idea is that this is a work in progress in Ecuador. So this is only 15 years. In legal terms, 15 years is very little time. But to date, we have at least 10 decisions of the Constitutional Court of Ecuador, which is the highest judicial body on constitutional law interpretation. In 15 years, we have at least 10 decisions, most of them of erga omnes effect. So the performance of jurisprudence in Ecuador in this particular subject is very high. Some people say there are other more than 10 decisions, but I use a conservative approach, 10 decisions specifically addressing the rights of nature. These cases, the cases that that have provided jurisprudence are very complex cases because these cases address the relationship between human rights, such as labor, such as property, such as economic development. They address the relationship with human rights, the rights of nature, and sustainable development. Okay? And in general terms, they refer to ecosystems. For example, industrial projects taking place in biodiverse areas, mining projects, oil exploitation projects taking place in highly biodiverse areas. They address rivers issues. For example, hydropower plants, which is clean energy, reducing or diverting the natural flow of the river. with consequences on the ecological flow. And the topic that is very important for the court, species, and they address habitat loss and prevention of extinction of endangered species. So these cases are not easy. On the contrary, they are very complicated. And I will just explain 3 cases, just as a little summary, to make sure that you understand the difference between environmental rights, human environmental rights, and the rights of nature. In Los Cedros case that Jaffa already explained, in this case, an environmental permit was issued, was given to explore industrial mining in a forest. Yeah. This forest is not part of the national system of protected areas, but nevertheless, it holds important ecosystem. The authorization was issued because it met environmental laws standard, because this mining operation was categorized as low environmental impact. When this case went to the Constitutional Court, the court revoked the environmental permit because the forest holds a fragile ecosystem, and that forest is also the habitat of hundreds of endangered species. So you see the difference? In the context of environmental legislation, this activity was authorized. But in the context of constitutional law, this activity was not authorized because it violated the rights of nature. The perspective of the court was not the difference between a forest or a protected area, was not the level of environmental impact. The focus of the court was that that forest was the habitat of species that in some cases were critically endangered. And therefore, they have to enforce the rights of nature in order to prevent the extinction of the species as well as the damage to the fragile ecosystem. In another case, this is the difference between administrative law and constitutional law. This is a case about the issuance of an administrative permit to take the water flow of a river, a Kepi river, up to 90%. This is actually allowed by environmental law for industrial purposes. This is a good standard for environmental legislation and administrative legislation. When it went to the court said that taking 90% of the water of the river will mean that the river will lose the ecological flow. And the river does not only serve for human purposes, but also it is the habitat of 19 endangered species. Okay? And therefore, the court also revoked this administrative authorization. In order to, I don't have too much time, but in the Q&A questions, I would like to explain the mangroves case as well. But I just wanted to share with you these experiences in order for you to visualize the changes that have taken place in Ecuadorian legislation. In the side of environmental rights, the legal subject is a human being, is the natural person. In the rights of nature, the legal subject is nature herself. Okay? In the context of administrative law and environmental law, the idea is to protect nature as an object, as something to protect. Whereas in the rights of nature, the idea is to respect nature because of her own intrinsic value. All right? It's something and someone. And finally, and this is very important, in the area of environmental law, we are talking about administrative law. basically regulating how to use a natural resource. Whereas when we address the rights of nature in Ecuador, we are talking about constitutional law, principles, rules, and also tools. It is a different scenario. This leads to the conclusion that the rights of nature belong in Ecuador, they belong to constitutional law, not necessarily to environmental law. This also means that standards are different. The court is setting higher and in some cases additional standards than the one provided by environmental legislation. This means that environmental permits not always guarantee the rights of nature. Okay? And the rights of nature in Ecuador are autonomous. They don't belong to, they are not an appendix of environmental rights. However, this it is also important to say that being autonomous, they are also complementary. They are interdependent with other constitutional rights, including environmental human rights. And as Yafa highlighted, in the rights of nature context, there is a strong, a serious, a very solid dialogue between law, science, and engineering. This is a reality in Ecuador when it comes to the rights of nature. And to conclude, as I mentioned in the beginning, we are debating now the role of the law in shaping a new relationship between the human and nature because of the rights of nature. See, this is now an emerging trend that has to be seriously addressed. I like that panels like this are now more frequent because it allows to explain what is the scope of the rights of nature. This is a very interesting emerging trend. There are different models, and the case of Ecuador shows that the coexistence of anthropocentric and non-anthropocentric approaches are possible, and in some cases can be effective to achieve the goal of environmental protection. Thank you very much.
Thank you, and thank you for making this as concise as you could. We'll move immediately to Professor Kim, and for him the question is broader but also specific in one way, is does China's ecological civilization provide some implications for rights of nature from the perspective of the law? Thank you.
Okay, thank you, Felipe. Yeah, I'm very pleased to be here to share my understanding about the relationship between the law, the existing law, and the rights of nature. Especially, I got learned a lot from the two colleagues from Yafa, from Hugo. Their presentations, for me, I think it's more in a positive law perspective. My presentation, if my colleague can help me to share the screen, to provide my understanding about the ecological civilization, is more from a more philosophical way to think the rights of nature. Because when we talk about the law, when we talk about the rights, normally we will understand the rights is kind of a moral law, moral rights or legal right. And it's, if when we from the previous presentation by Hugo, I found there's a lot of deep development in Ecuador. But for me, I think I prefer to think it is how we improve the law, how we reform the law to protect the environment, to protect the nature more precisely, in a more scientific way. So behind that, the rationale for me is kind of the way of thinking. So that means how we understand the civilization, what kind of a civilization, what kind of relationship between the human being and the nature. Currently, we have about 4 different types of civilization. We have primitive civilization, agriculture, industrial, and on the different civilization, we have a different approach on the relationship between the human being and the nature. For example, human being revenge the nature, follows the nature, or conquers the nature. Next slide, please. Yeah. Next slide, please. Yeah. So if and currently we are more in industrial civilization. We have a lot of problems, environmental problems. So we can see the climate change, biological diversity laws, and the environmental pollutions. So all these situations, all these problems forced us to think how to protect the environment, how to protect the rights of the nature. So now we have the new approach about thinking the relationship between the human being and the nature. That is the origins of the ecological civilization. Actually, this term was originally raised by a Japanese scientist and later by a very famous American writer and critic, Roy Morrison, who used this concept, ecological civilization, specifically. Yeah. Next slide, please. Yeah. Next slide. Yeah. And this ecological civilization, actually, we can also find the root in the traditional Chinese philosophy. The Chinese traditional philosophy is have a very key component. Is kind of the human being is an integral part of the nature. The people must be in a harmonious way with the nature. Next slide, please. This kind of scientific concept has been gradually translated into the policy stage. You can see from the year of 2007, the Chinese, the ruling party, the Chinese Communist Party has proposed the ecological civilization into its ruling policy documents. And until now, next slide, please. Yeah. Till last year, on the year 2020, we can see the ecological civilization has been included into the China's constitution. So it has become from a scientific term to a political term. Now it's a legal term. Yeah. Next slide, please. Yeah. So the most important the content of the ecological civilization, I think is a very good combination of China's traditional value of harmony and integration and with the sustainable development. So we can see that ecological civilization, as mentioned by the Chinese President Xi Jinping, is a major achievement in the progress of human society. Ecological civilization is the product of industrial civilization to a certain stage of development, which requires harmonious development between the man and the nature. And the human can use the nature and transform it, but in the end, they are part of the nature. Human must take care of nature, but not override it. We must resolve the contradictions brought by the industrial civilization, and empty the harmonious coexistence between the man and the nature to achieve the sustainable development of the world and around the development of the humans. Next slide, please. Next slide, please. Yeah. So now we can see there are a lot of for the content of the ecological civilization. We can see the fundamental guarantee is they have different points of view, from the profound historical view, scientific view, as to the relationship between the economic development and the environmental protection, is green development, and it also use kind of holistic and systematic view to protect the ecosystem with all different components, and use the strict rule of law to protect the environment, and so on and so on. So next slide, please. Now also we can see the people under the primitive civilization, the humans reverence for nature. Under the agricultural civilization, the humans follow the nature, and under the industrial civilization, the human conquers the nature. But now on the ecological civilization, that's kind of a harmonious coexistence of the humans and the nature. So that's the most important philosophy view of the point. Next slide, please. Next slide, please. Yeah. So that means, well, that is very important to say that also mentioned by Hugo just now, by my colleague. So how to understand the person in the environmental law? That means the subject, the legal subject. We can say the subject is a human being, or subject or as a nature. For me, I think the law, the legal subject is still the person, but we have different understanding of the people. The human, before we think the person isolated from with the nature, but now when we look at the person, the legal concept of the person in the environment is the human being exists in the nature, and the human being exists in the society. Next slide, please. Now we have in order to achieve the ecological civilization, we have at least 4 different legal principles. The first one is the ecological priority. That means that when there are conflicts between the environment and the development, we must put the environment, put the nature as a high priority position, and we must have a kind of achieve kind of a green development. That means that we need a kind of a sustainability, means we should pay attention to achieve integration of the economy and the environment, and we should use a kind of a precautionary approach to deal with the environmental situations, like issues like climate change, like the biological diversity loss. And finally, we should have a kind of integrated governance. We should use the government, industry, and civil society all together to protect the environment. Next slide, please. So that means when we talk about the ecological civilization, we can find this this is a 5-in-1 shape, a 5-in-1 organ. That means the ecological civilization is with the economic civilization, political civilization, cultural civilization, and social civilization. So all 5s are into one. So that is the main context or the main implications for the ecological civilization. So what is the implications of ecological civilization for the law, for environmental law, for the nature of the rights of the nature? So when we took the ecological civilization as a kind of a strategy or model, we will obviously we will change, we will reform our way of development. We will reform our environmental law to be more, to be more environmental friendly. And for example, the environmental permit system, ERA system, and other system, all kinds of environmental law systems should be changed or should be reformed into a more ecological friendly way. That when we have this kind of legal philosophy, when we have this kind of legal system, as a result, the environment will be protected very well. The right, if we regard this, the nature have the rights, that the rights of the nature could be respected, could be maintained, could be protected very well. So that is the most important. On one hand, we need to reform our environmental law system to protect the rights of nature. On the other hand, or more important, we must have a new way of thinking. We must have a new legal philosophy for the future, for the nature rights of the nature. So that's my very short presentation. Philip.
Thank you. Okay, now we'll follow up to keep some dynamic among the speakers and to make sure everybody stays engaged with a follow-up question on each of the presentation, and also to allow each of the speaker to react in a way to each other. And this time we'll go in the reverse order. So I'll start with Tianbao, because that means you have two options, right, one after the other. And the question for you would be, how does the concept interface, the concept of right of nature, interface with the human right to a clean, healthy, and sustainable environment? So following up on what you just presented.
Thank you. So as we all know, that the concept rights of the nature is not a brand new one. It's new, but it needs to be explored in a more comprehensive and systematic way, actually. Basically, we can understand the rights of nature in two different ways. One is a very radical way. We can regard the rights of nature as a new type of legal rights, but the subject of the rights is nature. It's not a human being, as mentioned by Java, by Hugo. On the other way, another point of view is that the concept of rights of nature is more like a tool, or more like a way of thinking to help the existing environmental law or general law to be reformed, to be strengthened, or to be implemented or compliant, enforced for the benefit of the rights. So that is the very important important point to mention, that when we talk about the rights or right of the or human rights, actually there are two models. One model is that we empower the right to the subject, to the legal subject. Another way is we impose the duties or obligations to governments or other subjects. So this is two different approach. So for some countries, I think they have to the environment, right to the environment. We have the resolution last year by the UN, but actually, according to my limited observation, the majority of the countries, although they have the right to the environment in their constitutions, but actually it's very difficult to sue, to use the litigation to protect, to enforce the rights. So that means the more practical ways to impose the duties of the state to. That means that the states have the duty to protect the environment. The state have the duty to improve the environment. So essentially the rights of the nature has been respected, has been stored, has been restored, has been protected. So the model of the protection, these two different model of protection of right to the environment actually have a very similar way or implications for the future right of the nature, or they have some overlapping part between the right to the environment and the right of the nature. So when we protect the right of to the environment of the human being, in some way, for me, I think it's already we protect the right of the nature. So that's my very short feedback. Yeah.
Thank you. Now I'll move to Hugo. Now, building on what you've presented in terms of Ecuador, the question would be in terms of the scope of rights of nature in comparative framing among Latin American states. So Bolivia, Colombia, Panama have followed in terms of providing different approaches to developing rights of nature. And since 2021, Chile and Aruba are also discussing its constitutionalization. So if you could tell us a little bit more about that.
Thank you, Philippe. Indeed, Latin America is at the moment providing several examples on how to address this relationship between humans and nature in a context of the 21st century. Scholars have identified at least two currents, two trends on this debate. The leading trend is the one that advocates for the greening of current environmental law. This is the leading trend in Latin America. It's staying within the borders of environmental law and make it better. And the other current, the minority current or trend, is the rights of nature trend, led by Ecuador and other countries that are following the model of Ecuador. Colombia, for example, has provided for important jurisprudence, the Atrato River decision that is worldwide known. Panama last year put into force a very detailed law on the rights of nature. Bolivia, of course, since 2010 has a very interesting law on nature from more indigenous collective rights perspective. And right now, both Chile and Aruba in the Caribbean are debating on constitutional change within the context of the rights of nature. So as you can see, things are happening here. This doctrine is already being put into practice. Of course, it's too early to conclude what will whether or not this is a good idea or this is a bad idea. But the fact of the matter is that this is a reality in Latin America and not only in Ecuador.
Thank you. And now one last question to Yafa. To what extent is rights of nature departure from current environmental laws, which really link with everything that we've already talked about in a broader framing?
Yeah, and certainly as some, I noticed some people took up in the chat, there are a lot of different forms to rights of nature laws, and some can be quite innovative, and or they can look more similar to existing legal structures. Rights of nature advocates certainly hope that they're going to be a departure from existing laws in terms of their impact. But of course, non-human legal persons are not in any way new. And I don't think that there are significant legal barriers to designating non-human natural entities as legal persons. One counter argument is that corporations really have human interests behind them. But of course, so do most rights of nature laws, which often include humans as part of nature or rights holding natural entity or ecosystem. The Colombian Supreme Court, for example, in its decision declaring the Amazon ecosystem to be a subject of rights, argued that nature has intrinsic value in itself, because people have intrinsic value and people are part of nature. Further, as I've argued in the Modern Law Review article that you mentioned earlier, many current environmental laws already do purport to protect the environment, at least in part for its own sake, beyond the protection for current and future generations. For example, nearly every country has laws that implement the Convention on Biological Diversity, which acknowledges the intrinsic value of biological diversity. So therefore, I argue, we already owe legal obligations to protected natural entities, and that we have obligations to protect them for their own sake. And this isn't different, at least in the Hohfeldian sense, from these natural entities having rights. So I would argue that rights of nature is not necessarily a departure from environmental law at all, in that nature has this sort of rights already.
Thank you. Now we'll move on to the Q&A section where we have quite a number of questions. Sabrina and I will try to bring them to each of the speakers according to what we understood was maybe the most relevant ones, and we'll try to club a few of the questions to make sure we can address them all. But since we have quite a few, I guess we'll have to say that the answers should be relatively short, not too short, but relatively short. So Sabrina, you'll start us off.
Thank you, Philip. I think we'll start right at the beginning. A question we would like to address to Dr. Epstein, if this is all right to you. So the right of nature movement is huge and diverse. As this listener understands, there are two legal recognition of nature, legal recognition of a specific river or forest, and legal recognition of all natural resources. Is this a valid interpretation, and does this approach create a challenge? And if yes, how can it be addressed?
So I think I would actually put the question to Hugo, because Ecuador, of course, is one of the main jurisdictions where there is rights for nature writ whole. And how that's played out, and my understanding is that the rights of particular natural entities keep being declared, or in each case there's often a new rights holding entity. But yeah, I would be interested in Hugo's answer to that question.
Sabrina, could you please repeat the question? I was checking out the question of Sophia Chivers that I would like to answer later on.
Yes, I see you were typing and responding to the questions at the same time. So we have the question is actually the first one in the Q&A session.
Yep.
The variety of the rights of nature movement is huge, and this very question is about the two legal recognition of nature. One is understood to be legal recognition of a specific river or forest, and the other one legal recognition of all natural resources.
Yep.
Is this a valid interpretation, and does this approach create challenges?
And the reason I toss it to you is because, of course, Ecuador has this holistic view, but is creating many different legal persons.
Thank you. In Latin America, there are both perspectives within the context of the rights of nature. For example, take the case of Colombia. In Colombia, the approach is recognizing rights to a river or rights to the Amazon, a specific river, a specific forest. In Ecuador, the recognition is integral, is nature as a whole, including ecosystems, the species, and all elements of nature. So within the Latin American context, you can find at least these two approaches. Which one of them is better? Difficult to conclude, but certainly both approaches are valid in the context of Latin American, and there are experiences as well. In Panama, there is a law recently enforced that actually recognized rights to sea turtles. It's very, very specific, like the Spanish case on the Mar Menor Lagoon.
Thank you. Philip, over to the next one.
Okay, fine. I didn't realize we went there. Okay, so the next question is, can legal rights be extended to mutated virus? Where do we draw the line? We're thinking maybe Jianbao.
Okay.
Obviously,
So
you can send them back to others if you don't like our choice.
I think it's from a more realistic way, from a more positive law approach. I think obviously we have exciting development in Latin American countries, as Hugo mentioned, but we cannot easily find a similar development of the legal recognition of nature in European countries or in African countries, other countries. So it's we will have a lot of legal problems, legal difficulties in defining the subject, the content, the object of the right or legal right when we talk about the rights of the nature. So for me, it's morally we can entitle the rights to the nature, but legally it still have a lot of difficulties. So it's the same to the question mentioned, mutated virus. It's quite difficult.
Could I add that, well, perhaps I think the law probably could create a rights holder that was a virus, but if you're representing an NGO that's trying to convince courts to enact rights of nature, I'd recommend you start with something more cuddly.
Thank you. Would like to continue with the question on how do rights of nature intersect with and compel changes to property rights and legal philosophies of ownership of land and nature. Maybe Dr. Epstein?
Yeah, that's one of the big questions. And I think that how the rights of nature are weighed against existing rights of people and of corporations is going to be one of the questions that's going to be answered differently in different under different laws and in different legal systems, and will be a big key in whether those new laws are effective.
Yeah, can I have a little back? Yeah, so we can see the right to exist, right to evolve, and right to be restored. So all this kind of, for me, I think is more like a natural right. It's a kind of a natural law, It's not a legal right. Yeah. So it's quite difficult to impose the right of nature to the right to the property or other existing rights. With human beings,
Okay, there are two questions that maybe can be kind of brought together. One is, do you think that adoption of rights of nature framework by developing countries will create a double burden for developing countries, since rights of nature may constrain the pace of growth necessary to ensure other human rights? And the second, maybe slightly related question is this harmony of ecological civilization, does it go hand in hand with the concept of development in a country that's still trying to bring their citizens beyond the poverty line? Okay, actually, that could be several of you. Starting with Tianbao.
Yeah, okay. So once again, when we talk about the right, is from the legal perspective, we must to define exactly what the rights are, what are the subject, how to exercise the rights. So if we cannot currently we cannot give a very clear answer. It's very difficult for us to promote the wider acceptance of these rights. So when Hugo mentioned the development in Latin America, because I don't understand Spanish, so I don't know exactly how the development of the cases. But for me, I think it's more like more specifically, it's more like duties of the government to consider the how to protect the environment. It's not the right of the nature itself, but we can say it's the right of the nature. But actually, it's the duty of the government, of the industries. They have a more and more clear and more scientific obligations or duties to protect the environment. Use a holistic way, use a ecosystem way to protect them.
Thank you. Then let's go on with another question, which is how much overlap are you generally seeing between indigenous rights and rights of nature? Do most frameworks connect them, or are they seen as separate issues in most models? I believe it would be interesting to hear on that from Dr. Echeverria.
The case of Latin America and Ecuador in particular shows that the way to go is to connect, using Sophia's wording. The approach that has proven to be effective is to complement the rights of nature with all other constitutional rights, including indigenous rights as well as environmental rights. Just to give you an example, the jurisprudence on rights of nature is based upon the most important principles of environmental law, such as the precautionary principle, or the principle of common but differentiated responsibilities. So when you see what is happening in Ecuador and in other countries in Latin America is not an exclusion approach, but a connection approach, a complementary approach. That is the word that the Constitutional Court of Ecuador uses. The rights complement each other. So by doing so, instead of fighting between environmental law and the rights of nature, they join forces and become become stronger. Another example that I want to give on the question on the role of the rights of nature and property is that using the environmental law concept of the ecological function of property, or the environmental function of property, the rights of nature take this idea a little bit beyond and actually sets higher, stronger limits to the right of property, okay, in order to respect nature. So this is why the rights of nature have become not comfortable, very, very uncomfortable for industries using natural resources, because the standards they are setting are higher than the ones set by environmental legislation, at least in the case of Ecuador.
Okay, maybe we'll take one more question, and then maybe we'll let the panelists decide if there is one of the remaining list that they want to specifically address, since we're slowly moving towards the end. So to discuss something else, and that I'll leave any of you to address, because that's a different topic: humanitarian law and rights of nature. So the question is on Article 35.3 of the additional protocols to Geneva Conventions, talking about the environmental provision that talks about widespread, long-term and severe damage to the natural environment. And the question about asking you, I guess this time I'll say any of you, how you see that in terms of the historical development of global ecological law, and whether that can be seen as a starting point of what we're talking about today, or in a way, I guess, in the longer term perspective. Whoever wants to start.
Can I begin?
Please.
Okay. I think, look, I think that that's the main contribution of the rights of nature. The rights of nature have come to reactivate the debate, the dialogue, the debate, the discussion on what should law do in order to be more effective regarding the protection of the environment. I don't know what will happen in the future regarding the rights of nature. This is a concept that not very many like. Many would like the rights of nature to be taken out of the debate. But the most important contribution I see of the rights of nature is we are actually talking about this. We are acknowledging that environmental protection has not always been a goal that has been met, not at least fully met, and therefore there are alternatives to take a look on, and one of them is the rights of nature. So I think this is we are entering into a new momentum, not only within environmental law, but most importantly within constitutional law and also international, public international law.
Any additional?
Yeah, and you could also mention that the idea of ecocide is also trying to explicitly draw parallels between human rights and environmental rights, I suppose. And I think anytime that laws are made for the benefit of the environment, we could consider that a type of right that helps inform what our obligations towards that natural entity is.
And maybe just before we go to the last set of rapid fire questions, one easier or lighter maybe question in terms of what can be the role of law schools and professional associations to help advance rights of nature, and or can IUCN, WCEL? In either of the countries that you represent or internationally.
I think the Sabrina may be the best person to answer this question for the IUCN, but I'm a law professor at the university. For us, I think it's most important to teaching the environmental law, not only environmental law as mentioned by Hugo and Jaffa. So the greening of other law fields like the constitution law, like a public law, like a civil law, if we can transplant the idea of the protection of the nature or rights of the nature into existing law fields, that'll be very, very good for the future's development. Yeah.
Thank you, Professor. Dr. Epstein, would you like to respond to that?
Oh, I was just going to add that they can make good projects for law clinics. I think that the Spanish Mar Menor law involved a student law clinic.
Thank you. Well, I was going to move over to the next section, but take the opportunity to respond also to the question on what role IUCN can play in advancing rights of nature. And there I would like to repeat what I said at the beginning. Really, there is this base network of IUCN where we have space with this task force to discuss rights of nature, share best practices, share strategies that have been done to overcome challenges or things like that. So if any of you are interested to further engage on that topic and to maybe be part of the task force, do not hesitate to reach out to us, and we will be happy to see how we can move forward together. So now I'm also mindful of time. I see we have about 6 minutes left, but I wouldn't like to miss the last question because it's also very much forward-looking. So what is the next important step in the panelists' opinion to take with rights of nature? And here we go again, like what would be really nice if you can just give a few keywords, like really short answer, like this is the thing that the next step that needs to be taken in your opinion. I see Professor Jin has his microphone open. Maybe you would like to start?
Thank you. Yeah, so it's actually for me, although I'm a little bit conservative, but I'm looking forward the radical development of the concept and the practice of rights of the nature. I think this new concept is more like a way of thinking, a point of view to promote the law scholars, the legal scholars, to think the rule of law in protecting the nature and in protecting the rights of the nature. It's very important, a new concept. Yeah.
Thank you. Dr. Echeverria?
Well, the immediate next step is actually what we are doing right now. Is setting up a dialogue to better understand these new concepts that are often seen with a little cautiously. This concept, in my opinion, has come to stay. Whether and therefore we should understand it better. I think this is a very important role of academia, role of the IUCN, for example, yeah, to help a better understanding and a better dialogue between environmental law and the rights of nature and other areas. Another step that might be in the mid-term is to begin addressing the rights of nature in the context of human rights courts, like the European Court on Human Rights, the African Courts on Human Rights, and the Inter-American Courts on Human Rights. This is already happening in Latin America. Right now, there are cases on climate change emergency that are setting up scenarios to begin talking about not only the role of climate change in affecting human rights, but also the role of climate change affecting the rights of nature herself. So this might take a little time to go, but it is important to begin addressing environmental law issues in the context of nature herself.
Thank you.
Yeah, I agree with what's been said. I think lawyers in we need lawyers in different areas of law, constitutional law, administrative law, as well as environmental law, to take rights of nature seriously. There's huge public support for these laws, and they keep getting enacted. And I think that as lawyers, we need to examine seriously how these can be drafted to actually be effective, to be compatible with the particular constitutional and administrative laws in the legal systems in which they're enacted. And as I've said before, I think we also need to be talking to scientists to make sure that these laws can be both legally effective and actually implemented.
I will just like to add, yes, it is essential. It is very, very important to include science and engineering side by side with the law. This is a long aspiration of environmental law. Science, environmental law is interdisciplinary by characteristic, by feature. And the rights of nature are actually doing that. Like Yafa mentioned in the Los Cedros case, in the Ecuadorian case, the judges actually invited scientists and engineers for all over the world to provide inputs to make a legal sound decision.
Yeah, I I fully agree with the last comments by Hugo. The most, when we talk about the legal protection of rights of nature, maybe one of the most important things to translate the scientific rules into the legal rules. So we must follow the natural rules, the natural consequence. We follow the nature, we respect the nature, then we can protect the nature.
Thank you, Professor. I think these are quite nice closing words from the whole round of panelists. Thanks a lot to conclude with such wise words. And I see we're now exactly at 1.5 hours. First of all, I know there are still some questions left in the Q&A section that we didn't manage to respond. Please note they're well noted. We will see if there's some form that we can respond to them. Some of those questions might also be addressed in the further work of the task force. So there again, if you really have something that's that you would like an answer to, please do not hesitate to reach out either to me or Philip, and we will make sure that these questions get answered by the respective experts. Therewith, I would like to give enormous thanks to the 3 panelists. It was a great pleasure to have you with you. Thank you so much for giving this time to WCEL and the webinar. It was a very interesting discussion covering the whole variety of rights of nature. I hope the audience has enjoyed it as much as we did. Philip, would you like to have some more thanking words?
Okay, just one practical thing. I know there are at least 3 people whose questions have not been answered. I've just put my email in the chat. As we can't chat with you individually here, if you could send me an email and I'll try to either address the question myself or ask the speakers if they're happy to address them afterwards, so that you don't stay unanswered. Otherwise, I'll just say thank you to the speakers, all the participants for the many questions, clearly too many questions. And this is really stimulating. I'm sure there's a lot more to be done, and I'm sure we will all do more in the future. Thank you.